Assalamualaikum warahmatullahi wabarakatuh. Good evening to everyone, especially to our law professor, Attorney Muhammad Muqtadir Ahmad Estrella. Good evening, sir. Tonight we will discuss the revised Code of Professional Responsibility and Accountability, specifically Canons 4, 5, and 6. At this point, let me introduce the Group 4 reporters, starting with yours truly, Capablanca Maria Loresa Isabel F., Blo by Mohaira Faika, Amir Haron, Malen by Ali, Bugay Edu, Yap Chihana, Bilao Morsid, and lastly, Bagundang Ali Fami. And this will be the topic to be discussed under Canon 4, sections 1 to 10, pertaining to competence and diligence. Under Canon 5, there are 4 sections pertaining to equality. Under Canon 6, there are 6 sections that are pertaining to accountability. This new Code of Professional Responsibility and Accountability serve as a comprehensive framework guiding the ethical conduct of lawyers in the Philippines. It outlines specifically the ethical standards that a lawyer must adhere to in practicing the profession. Ethics is indeed a reflection of moral standards and an integral part to the administration of justice. So, as a law students, we need to equip ourselves with what are those standards as a preparation, inshallah, in practicing law.
To start the discussion of Canon 4, competence and diligence, I think it is better to understand first its general statement, which reads that a lawyer professionally handling a client's cause shall, to the best of his or her ability, observe competence, diligence, commitment, and skill consistent with the fiduciary nature of lawyer-client relationship, regardless of the nature of the legal matter or issues involved, or whether for a fee or pro bono. What is actually being contemplated in the general statement is that it is not only being good of what you do, but also how you treat your clients and how you handle the case. So, what does competence mean? Competence refers to the knowledge, skills, and ability that a lawyer must have or possess in order to effectively represent his or her client. That means that a lawyer is expected to have the necessary skills and understanding of the law. So what does it mean that a lawyer must also observe diligence? Being diligent involves that a lawyer must be persistent, careful, and thorough in handling legal matters. So for example, if I am the counsel for the respondent and I already received the copy of the petition coming from the counsel of the plaintiff, then that means that I have to submit an answer to that petition in timely manner as provided in the rules of court. I can only be diligent if I am also competent. Under the general statement of Canon 4, competence and diligence, it also mentioned about fiduciary nature of lawyer-client's relationship. That means that there must be a mutual trust between a client and a counsel in a way that client relies on his or her counsel and counsel keeping in mind that his actions must be of the best interest of his or her client. And lastly, regardless of the nature of the legal matter or issues involved, and whether for a fee or pro bono, that means that every client deserve the same level of dedication, the same level of competence, the same level of diligence expected from a counsel, notwithstanding his or her financial status and standing of the case. In summary, Canon 4 emphasizes that a lawyer must always strive to be competent and diligent. This involves not only having the right knowledge and skills, but also committing to act in the best interest of his or her client. Section 1 of Canon 4, which states that a lawyer shall provide a legal service that is competent, efficient, and conscientious. A lawyer shall be thorough in research, preparation, and application of legal knowledge and skills necessary for an engagement. What is actually being contemplated in Section 1 of Canon 4 is that a lawyer should provide a competent service, an efficient service, and conscientious service, but this could only be made possible if the lawyer is equipped enough with necessary skills and knowledge that he or she could effectively apply in legal situations like negotiations or court appearances. Additionally, those lawyers who take their responsibility seriously and deliver a quality service build a strong reputations which help their careers in the long run. In summary, this section emphasizes that a lawyer must be well-trained, work in timely manner, and dedicated to their clients to provide the best legal service possible. Section 2 of Canon 4, first paragraph provides that a lawyer shall only undertake legal services he or she can deliver. And on its second paragraph, it states that with the prior written consent of the client, a lawyer may secure the services of a collaborating counsel. What is actually being contemplated in paragraph 1, section 2 of Canon 4 is that a lawyer shall only take cases or tasks that matches their skills or expertise. While on the second paragraph, before a lawyer could actually secure a collaborating counsel that will somehow bring an additional expertise, providing or enhancing better a legal representation, he or she must secure a written consent that is coming from his client. Section 3 of Canon 4, first paragraph provides that a lawyer shall diligently and seasonably act on any legal matters entrusted by a client, while on its second paragraph it provides that a lawyer shall be punctual in all appearances, submissions of pleadings, and documents before any court, tribunal, or other government agencies, and all matters professionally referred by the client, including meetings and other commitments. Section 3 of Canon 4 emphasizes the importance of punctuality and diligence in a lawyer's professional conduct. It actually requiring the lawyer to be active and being prompt in handling legal matters in a way that they show respect to their client's time as well as respect to the entire legal process. Additionally, this section also mandates that a lawyer must be punctual in all of his professional commitments, such as, for example, submitting a document in timely manner, as well as informing the client of the updates or any updates regarding their cases. To reinforce my discussion about Canon 4, competence and diligence, specifically sections 1 to 3, let me give you the case of Alifer Sepante versus Attorney Jose Alan Imtibelen. So the facts of the case. Actually, this case is between a client and a counsel where the complainant, Alifer Sepante, seeking the nullity of his marriage, and the respondent of the case is his counsel, Attorney Jose Alan Imtibelen. On July 13, 2012, they come up with an attorney-client relationship. They agreed on the amount of 200,000 as a payment to be paid for the professional fee of the respondent. Same day, July 30, 2012, the complainant gave 30,000 pesos as his down payment, and few days later, he went with his counsel to a psychologist, and then there he actually gave additional payment of 20,000 pesos. On September 30, 2012, while the respondent together with his wife is having together inside the mall, he called the complainant to ask for an additional 19,000 pesos as a down payment, and he could also give the copy of the petition that accordingly to him he filed with the court. On February 13, 2013, the following year, the complainant and the respondent agreed to eat together in a restaurant where they talk about the case. So particularly the complainant asked the progress of the case, specifically when the hearing starts, and the respondent told him to just trust him and just wait. And additionally, asked for additional 51,000 as a down payment. After a few weeks, the complainant tried to contact the respondent to ask for the status of the case, but unfortunately, he rarely answered his messages. This prompted the respondent to personally inquire with the RTC Branch 109 of Pasay City about his petition, but to his surprise, the case number that was written in the petition paper that he is holding actually belongs to another case. The complainant tried again to contact the respondent but still no answer. That's why, due to the circumstances, the complainant resorted to threaten the respondent that he will going to file a case before the Integrated Bar of the Philippines. That only then the respondent responded on his messages and called. After the incident, without securing a prior written consent coming from the complainant, Attorney Tibilen hired a collaborating counsel. Since then, the complainant never heard from the respondent, and later he learned that the respondent was not able to pay the filing fees despite having receiving the amount of money coming from him. The complainant thus decided to seek help from the public attorney's office, who referred him to the IBP. The complainant and the respondent meet and talk at the IBP twice. Then the latter executed a promissory note for the former, where for such reason, the complainant held back on filing a case against the respondent. On February 22, 2014, the respondent went to the complainant, who was then confined at Viluna General Hospital, in order to borrow 50,000 pesos for his children's tuition fee. On the same month, he come back again to ask for 16,000 pesos allegedly to pay the psychologist. On May 14, 2014, the respondent once again asked complainant for another 16,000 pesos, but unfortunately, his savings were running low, so that what he gave was 14,000 pesos to the complainant. Then later, complainant discovered that the respondent did not pay the psychologist, while he only 5,000 pesos for the publication. Complainant never heard from the respondent and was pushed through to avail the service of another lawyer. And after that, he filed an administrative case against the respondent.
The issue before the court is whether respondent's acts violated the Code of Professional Responsibility and Accountability to merit the penalty of disbarment. The ruling of the Supreme Court: yes, respondent's acts violated the Code of Professional Responsibility and Accountability to merit the penalty of disbarment. Indeed, Attorney Jose Alan Imtibelen violated the sections 1, 2, 3 of Canon 4, where he was not able to observe competence, diligence, commitment, and skill consistent with the fiduciary nature of the lawyer-client relationship. In this case, since the respondent failed to provide legal service that is competent and diligent, as evident on his acts of subsequent failures from paying the filing fees, submitting the pleading, and the filing of motion to formally offer the evidence, then he indeed violated the sections 1 and 3 of Canon 4. Moreover, he also failed to secure the prior written consent of the complainant before securing the services of a collaborating counsel. Then he also violated Section 2 of Canon 4 of Code of Professional Responsibility and Accountability. Conclusion: yes, respondent's acts violated the Code of Professional Responsibility and Accountability to merit the penalty of disbarment. And that's end my report. Thank you for listening. Again, Assalamualaikum warahmatullahi wabarakatuh. Peace, mercy, and blessings of Allah be upon us.
Assalamualaikum warahmatullahi ta'ala wabarakatuh. Hello everyone, my name is Bai Muhaira Faika Senswatlo, and I'm here to continue the discussion from Group 4. I will be talking about Canon 4, Competence and Diligence, Sections 4, 5, and 6 of the new Code of Professional Responsibility and Accountability. To start with, we have Section 4, Diligence in all undertakings. So, according to this section, a lawyer shall observe diligence in all professional undertakings and shall not cause or occasion delay in any legal matter before any court, tribunal, or other agency. A lawyer shall appear for trial adequately familiar with the law, the facts of the case, and the evidence to be presented. A lawyer shall also be ready with the object and documentary evidence, as well as the judicial affidavits of the witnesses when required by the rules for the court. Now, this provision underscores that the legal profession holds lawyers to a particularly high standard of diligence. This is because they are entrusted with their clients' most critical, if not the most sensitive matters. Diligence in this context goes beyond simply completing tasks for their clients. It actually requires lawyers to actually employ every honorable means, meaning they have to be more thorough or more careful or more attentive in every aspect of their work to secure for their client what is justly due him, or to present every defense provided by law to enable their client's cause to succeed. So, in other words, their clients shall receive the best possible legal representation so that their rights and interests are fully protected. Now, this section also highlights that lawyers must avoid causing delays in legal proceedings. So, this section provides that it is imperative for lawyers not to contribute to delays because delays in the legal system may prevent justice from being served fairly. So there is that principle that justice delayed is justice denied. Additionally, Section 4 emphasizes that the importance of preparedness. Lawyers need to be adequately familiar with the law or the relevant laws involved in their client's case. They must also have a comprehensive understanding of the facts of the case, and they must have all the necessary documents and evidence ready when the rules or the court may require them. This diligence, or this level of preparedness, not only strengthens their legal arguments, but it also upholds the integrity of the whole judicial process. So, by adhering to this duty of diligence, lawyers actually reinforce the credibility of the legal profession because the way lawyers handle their responsibilities have a direct impact to cases outcomes and um, and also the public's trust in the legal system. Therefore, a lawyer's commitment to diligence is not just a professional obligation at this point, but it is a moral and ethical duty. Section 5, Prompt and Objective Assessment of the Merits. According to Section 5, a lawyer shall, after reasonable inquiry, promptly give an objective assessment of the merits and probable results of the client's case. A lawyer shall explain the viable options to the client to enable an informed decision regarding the matter. Now, this section discusses three more responsibilities of lawyers: conduct a reasonable inquiry, give prompt and objective assessment, and provide an explanation of viable options to the client. With reasonable inquiry, lawyers are expected to conduct a thorough investigation into the facts and applicable laws to the relevant case. This would ensure that any advice or assessment made by them are based on accurate information, which would help for an effective legal strategy or legal representation. So this approach would strengthen the lawyer's ability to advocate effectively on behalf of their client. Now, once a lawyer completes the necessary inquiry, they must then deliver uh, they must then promptly deliver an objective evaluation of the case's merits and possible outcomes. Timeliness is crucial. Also, a prompt and impartial assessment helps clients to clearly understand the strengths and weaknesses of their case. So, therefore, this would enable them to set realistic expectations and make informed strategic decisions moving forward. Additionally, lawyers also have a duty to clearly outline or clearly explain all possible courses of actions available to the client. So this include the potential risks and potential benefits associated with each option. Providing this comprehensive overview would allow clients to make informed decisions that actually align with their best interests and legal objectives. So empowering clients with clear and well explained options upholds the principles of justice and professional responsibility. Section 6, duty to update the client. According to Section 6, a lawyer shall regularly inform the client of the status and the result of the matter undertaken, and any action in connection thereto, and shall respond within a reasonable time to the client's request for information. So this provision highlights the fundamental responsibility of lawyers to maintain transparency and have an open communication with their clients. At its core, an effective legal representation ensures that clients' rights and interests are fully protected. So, by providing regular updates, lawyers help clients stay informed about case progress and possible outcomes. This actually enables clients to make well informed decisions. Also, active client participation in legal proceedings is essential to achieving a fair and just result. So, without proper communication, misunderstandings can also arise or may also arise, leading to frustration and sometimes a diminished trust in the legal system. So, an effective and timely communication not only strengthens the attorney client relationship, but also upholds the integrity of the legal profession. So, by regularly updating or by consistently updating clients, informing them of actions taken, and promptly addressing their concerns, lawyers fulfill their ethical obligations and reinforce the trust placed in them, as well as the legal system. Now, to further understand Section 6 of Canon 4 of the CPRA, let us discuss the case of Camcam versus Bascos, AC number 13784, decided on November 8, 2023. It concerns Bernard M. Camcam as complainant versus attorney Efren Marcelino Bascos as respondent. So this is an administrative complaint for disbarment against respondent. So the facts of the case are as follows. On March 9, 2015, Bernard M. Camcam, the complainant, together with his niece, a former staff member of attorney Efren Marcelino Bascos, the respondent, engaged the legal services of attorney Bascos to file a case for declaration of nullity of marriage. The respondent agreed to handle the case and requested for an initial payment of 30,000 pesos, which the complainant agreed to, which the complainant paid. Despite the complainant's continuous follow-ups, the respondent failed to provide updates regarding the filing of the case until after months. So after 7 months, the respondent eventually filed the case before Branch 53 Regional Trial Court in Rosales, Pangasinan. On January the following year, the respondent requested an additional payment of 24,000 pesos for the publication of the case, which the complainant paid. After the filing of the case, the respondent again failed to provide updates on its status and despite repeated follow-ups from the complainant. So now, frustrated with the lack of progress and communication from the respondent, the complainant filed an administrative complaint for disbarment against the respondent. The Integrated Bar of the Philippines, Commission on Bar Discipline, or IBP-CBD, found the complaint meritorious to warrant further investigation. So the IBP-CBD thereafter issued an order directing the respondent, Attorney Bascos, to file an answer. But Attorney Bascos failed to comply. Subsequently, the IBP-CBD scheduled a mandatory conference. However, both parties failed to attend. Then the mandatory conference was rescheduled, but again, both parties failed to appear. The IBP-CBD then issued an order terminating the mandatory conference, but instead directed both parties to submit verified possession papers. Despite this directive, though, the parties or both parties failed to file the required submissions. So, in its report and recommendation, the IBP-CBD recommended the dismissal of the administrative complaint for lack of merit. However, it recommended that Attorney Bascos be fined 10,000 pesos for his failure to comply with the directives of the investigating commissioner. So the IBP Board of Governors issued a resolution approving and adopting the report and recommendation of the IBP CBD, thereby dismissing the complaint for lack of merit and imposing a fine of 10,000 on Attorney Bascos. Now, the issue here, so in this case, the issue is whether or not Attorney Bascos should be held administratively liable for failing to update the complainant about the status of the case in violation of Section 6, Canon 4 of the Code of Professional Responsibility and Accountability. The court ruled that the complainant failed to establish through substantial evidence that attorney Efren Marcelino Bascos violated Section 6, Canon 4 of the CPRA. Under the CPRA, lawyers are obligated to keep their clients informed about the progress of their cases. However, the complainant must present substantial evidence showing that the respondent willfully disregarded this duty. Allegations alone do not meet the required quantum of proof in administrative proceedings. In the present case, while the complainant alleged that the respondent failed to update him on the status of the case despite repeated follow-ups, he failed to present substantial evidence showing that the respondent willfully disregarded this duty. Again, mere allegations without supporting proof are insufficient to establish administrative liability. Therefore, the court dismissed the complaint for lack of merit. The respondent cannot be held administratively liable for violating Section 6, Canon 4 of the CPRA in the absence of clear and convincing evidence of misconduct. That concludes my report. Thank you for listening.
Good day, everyone. I am Harun Amir. I'll be discussing the Section 7, 8, and 9 of Canon 4. Section 7 is extension of time to file. A lawyer shall avoid asking for an extension of time to file any pleading, motion, or other court submission except when allowed by rules of court or good cause. When an extension is obtained, the lawyer shall not let the period lapse without submitting the pleading, motion, or other court submission except upon the client's decision not to pursue the case or any further or for other justifiable cause. So the first paragraph means that lawyers should file their submission on time. Extension of time should not be a habit or used just for your convenience. And also, you can ask for an extension if when the rules of court allows it, or there is a good cause or reason, like for example, illness, natural calamity, or unavoidable circumstances. So, example, a lawyer is scheduled to file a position paper on March 25, but the lawyer becomes sick and is confined in the hospital. That is a valid reason for a good cause to request a short extension of time from the court. But um, if a lawyer poorly manages the time, that is not a good excuse and may even a considered negligence. So the second paragraph means that if the court grants an extension, the lawyer must use it properly, submit the required documents on time. The lawyer should not also waste the time given by the court. So the only acceptable reasons for not submitting even after the extensions are first, the client decides to stop the case, or there is another valid or justifiable reason, like for example, there is an emergency and unforeseen events. Like for example, the court gives a lawyer an additional 10 days to file a motion for reconsideration. If a lawyer fails to file within the extension period without any good reason, it can affect the client's case and may result in disciplinary action. But if the client is later decides to withdraw the motion, then it's acceptable not to file anymore, as long as it's clearly the client's decision. So Section 8 is lifelong learning. A competent lawyer engages in lifelong learning through the continued development of professional skills. So why is lifelong learning important for lawyers? So number one, to stay updated with new laws and jurisprudence, to improve legal skills such as writing, advocacy, and negotiation. Number three is to continue practicing ethically and professionally. So, being a lawyer is not just about passing the bar and starting your legal career. The law is constantly changing. There are new laws are passed, rules are amended, and the court decision evolve. So, a lawyer must keep learning throughout in their life to stay competent and effective. So there is a called MCLE, which stands for Mandatory Continuing Legal Education, issued on October 2, 2001, of bar matter number 850. So it is a program that requires all practicing lawyers to continue learning even after passing the bar. So it is part of being a responsible and competent lawyer. So just like doctors, they keep updating their knowledge about new treatments. Lawyers also must keep updating their knowledge about laws, court decisions, and ethical standards. So, under the Rule 1, Section 1 of MCLE, its purpose is to ensure that throughout their career, lawyers keep abreast with law and jurisprudence, maintain the ethics of profession, and enhance the standards of the practice of law. So, keep abreast with law and jurisprudence, which means that laws and court rulings change over time. So a lawyer must stay updated with new statutes, revised rules of procedures, latest Supreme Court decisions, and others. Like for example, if a lawyer is still using old rules of evidence, they might lose a case because the law has already changed. So when maintain the ethics of profession, um, lawyers must continue learning about professional responsibility and legal ethics. So the MCLE ensures they remember and apply the confidentiality rules, conflict of interest policies, duties to clients, to courts, and to the public. So when enhance the standards of the practice of law, lawyers need to keep uh, improving their skills, not just their legal knowledge. So MCLA includes training on legal writing, courtroom advocacy, alternative dispute resolution, use of legal technology if there's any. So yun. So under the Rule 2, Section 2 of the MCLE is the requirements of completion of MCLE. So under the MCLE rules, bar number 850, the members of the IBP who are not exempted under Rule 7, which will be discussed later, are required to complete at least 36 hours of legal education activities with legal activities every 3 years. So these 36 hours are not random. They are divided into a specific areas. So at least 6 hours shall be devoted to trial and pre-trial skills equivalent to 4 credit units. At least 5 hours shall be devoted to alternative dispute resolution equivalent to 5 credit units. At least 9 hours shall be devoted to updates on substantive and procedural laws and jurisprudence equivalent to 9 credit units. Number 4, at least 4 hours shall be devoted to legal writing and oral advocacy, which equivalent to 4 units. At least 2 hours shall be devoted to international law and international conventions, which equivalent to 2 credit units. The remaining 6 hours shall be devoted to such subject as may be prescribed by the MCLE committee, equivalent to 6 credit units. While most lawyers are required to complete MCLE, there are exemptions. Some lawyers are exempted from complying with MCLE requirements. So under the Rule 7, Section 1 is exemptions. So these are the exempted of MCLE. Number one, the president and the Vice President of the Philippines and the secretaries and undersecretaries of the executive departments. Number two, our senators and members of the House of Representatives. Number three, the Chief Justice and the Associate Justice of the Supreme Court, incumbent and retired members of the judiciary, incumbent members of the Judicial and Bar Council, and incumbent court lawyers covered by the Philippine Judicial Academy Program of Continuing Judicial Education. Number 4, the Chief State Counsel, Chief State Prosecutor, and Assistant Secretaries of the Department of Justice, the Solicitor General, and the Assistant Solicitors General. Number 6, the Government Corporate Council, Department and Assistant Government Corporate Council. And number 7, the chairman and members of the constitutional commissions. Number 8, the ombudsman, the overall deputy ombudsman, and the deputy ombudsman and the special prosecutor of the office of the ombudsman. Number 9, heads of the government agencies exercising quasi-judicial functions. Number 10, incumbent deans, bar reviewers, and professors of law who have teaching experience for at least 10 years in accredited law schools. The Chancellor, Vice Chancellor, and members of the Corps of Professors and professor lecturers of the Philippine Judicial Academy and the governors and mayors. So there are also under the Rule 7, Section 2, other exempted parties. Number 1, those who are not in law practice, which is private or public. These are individuals who hold a law degree or have passed the bar, but are not actively practicing law. This includes people who are engaged in business owners, full-time professors, not teaching a law. So, number 2, those who have retired from law practice with the approval of the IBP Board of Governors. So, there are lawyers who have formally retired from the practice of law, and this retirement has been approved the IBP. So, like for example, 70-year-old lawyer who has decided to stop practicing law, so practicing law permanently, she needs to submit a formal retirement request to the IBP. Then the IBP Board of Governors will approve and will exempt to the MCLE requirements. So under the Rule 13 is the consequence of non-compliance. So if a lawyer fails to comply with MCLE requirements, there are serious consequences. So number one, a member who, for whatever reason, is non-compliant at the end of the compliance period shall pay a non-compliance fee. So even if the non-compliance is unintentional, the lawyer must pay a penalty fee. So this is to remind lawyers that MCLE is not an optional. It's part of their duty as professionals. So section 2, a member who fails to comply with the requirements after 6 day period of for compliance has expired shall be listed as a delinquent member of the IBP upon the recommendation of MCLE committee. The investigation of a member for non-compliance shall be conducted by the IBP's Commission on Bar Discipline as a fact-finding arm of the MCLA. So after the compliance of the period ends, lawyers are usually given a 60-day period to catch up. So if they still don't comply within the they time frame given, they will be tagged as a delinquent members of the IBP. So number three, section three is membership fees shall continue to accrue at the active rate against a member during the period she is listed as the delinquent member. So meaning, just because a lawyer is marked as delinquent, it does not pose their financial obligation. So the lawyer must still pay the IBP membership fee at the regular rate. So in one of the decided case of the Supreme Court, which is Mapalad versus Enchanes, the facts of the case, a verified complaint for disbarment was filed by Virgilio Mapalad Sr. against Attorney Asilmo S. Enchanes before the Integrated Bar of the Philippines on April 16, 2009. So the complaint centered on Attorney Enchanes' use of a false MCLE compliance number in his legal pleadings. He knowingly included this false information despite not having complied with his MCLE requirements at the time. So why is this a serious violation? Because number one, pleadings with false MCLE compliance number have no legal effect. Under bar matter, all lawyers must indicate their MCLE compliance number in all pleadings. If the number is false or fabricated, the pleading may be deemed legally ineffective or invalid. So this puts also the client's case in danger. Even if the argument are sound correct, the court may dismiss the pleading outright due to non-compliance. So in this case, the respondent violates the Code of Professional Responsibility. So the ruling of the Supreme Court is court orders should be respected not only because the authorities who issued them to should be respected, but because of the respect and consideration that should be intended to the judicial branch of the government, which is absolutely essential if our government is to be a government of laws and not for men. Whereof respondent Anselmo is in Chavez is hereby disbarred from the practice of law, and his name is ordered stricken from the rule of attorneys. So as a reminder to everyone, especially future lawyers, we are an officer of the court. Your duty is not only to your client, but the rule of law and to the justice system. Once you violate that duty, the consequences can be a career ending. So under the section 9, section of concurrent with another profession, a lawyer who is engaged in another profession or occupation concurrently with the practice of law shall expressly provide and pertinent contract the nature of service the lawyer is engaged to perform. So the practice of another profession or occupation shall not jeopardize such lawyers competence, integrity, probity, and independence in rendering legal services. So not all lawyers work in a law firm or courts. Some lawyers have another profession and occupation aside from being a lawyer. So, but even if a lawyer has a second job, there are important rules to follow to make sure ethics and professionalism are not compromised. So, if a lawyer has another profession aside from law, they must first clear state in the contract what kind of service they are giving, whether it's legal work or work under their other professions. Number two, this is to avoid also the confusion about whether the client is receiving legal advice or non-legal services. So the lawyer's other job must not affect their competence, their integrity, their probity, their independence. So example, para mas maintindihan po natin, um, Attorney De La Cruz, who works as a financial consultant, when she enters into an agreement with a client, she must indicate that this contract covers financial advisory services and not a legal advice. So this helps the clients understand the nature of their service and avoids the assumptions that acting as a lawyers in the case. So I think that will be all and maraming salamat po.
Assalamualaikum warahmatullahi wabarakatuh. I am by Ali Malien and I will be reporting about Section 10, Non-Legal Activities of Canon 4 and Section 1, Non-Discrimination of Canon 5. So to begin with, Canon 4, Section 10, Non-Legal Activities provides that a lawyer who engaged in business or other non-legal profession shall likewise observe the ethical duties and responsibilities of a lawyer under the Code of Professional Responsibility and Accountability. The Philippine legal system grants lawyers some latitude to pursue multiple professional endeavors. However, that latitude is circumscribed by the strict canons of professional responsibility designed to ensure that every client receives diligent, competent, and conflict-free representation, and that the public's confidence in the legal profession remains unblemished. In this section, non-legal activities refer to any occupation, business, or pursuit outside of law practice. So, examples of non-legal activities that may be subject to this rule include engaging in business or commercial ventures, holding public office or political positions, participating in media or entertainment, and or pursuing other professions or careers. So lawyers should clearly distinguish between their legal and non-legal activities to avoid any actions that could be seen as bundling or promoting them together in a way that violates rules on advertising or solicitation. Before accepting a new client or matter, lawyers must check for potential conflicts arising from their non-legal activities. Lawyers also must not use or disclose confidential information from a legal client in their non-legal capacity, especially when their roles overlap. So lawyers should also exercise caution with any form of marketing related to their non-legal activities, ensuring that it does not interfere with or compromise their legal duties. So the court has repeatedly sanctioned lawyers who faced conflicts between their clients' interests and a concurrent business interest. If, for example, a lawyer broker represents both the buyer and the seller in a land transaction, trying to earn brokerage fees and legal fees simultaneously. So this can rise to the level of unethical conduct if loyalty or confidentiality is compromised. So a lawyer who fails to abide by these ethical and professional norms while concurrently practicing another profession may face possibly administrative sanctions, civil liability, or criminal liability. Okay, so a case that is relevant to Section 10 of Canon 4 is the case of Pilar versus Attorney Balikod with AC number 92 decided by the Supreme Court on November 16, 2020. The case is a legal prelude on conflict of interest in the practice of law. So, the case involves Joel A. Pilar serving as the Vice President for Technical and Sales of Kallenborn Weartech Philippines or KWP, who filed a complaint for disbarment against Attorney Clarence T. Balicod. So, Pilar accused Attorney Balicod of conflict of interest for establishing and operating Angel and Lagan Technicam Philippines Incorporated or EAT, which directly competed with KWP while he was still legally representing KWP from 2010 to July 2013. During his tenure, Attorney Balicod was involved in drafting various legal documents for KWP. It was discovered later that Attorney Balicod incorporated EAT in March 2013 with close associates of KWP's former president, indicating conflict of interest and misuse of KWP's confidential business information for personal gain. Upon the complaint's filing with the Integrated Bar of the Philippines, an investigation ensued, resulting in the recommendation of a 1-year suspension for Attorney Balicod by the investigating commissioner of the IBP Commission on Bar Discipline, a recommendation that was adopted by the IBP Board of Governors. So, Attorney Balicod's motion for reconsideration was denied, leading to the elevation of the case to the Supreme Court for final resolution. So, the issues in this case is whether or not Attorney Balicod represented conflicting interests in violation of the Code of Professional Responsibility, and whether the establishment and operation of EAT constituted conflict of interest and breach of trust towards KWP. So the ruling is that the Supreme Court agreed with the factual findings of the IBP but modified the penalty. It was established that Attorney Balicod did represent conflicting interests by setting up and operating EAT, which directly competed with KWP, his current client at the time. The court found that this action breached the duty of undivided fidelity and loyalty owed to KWP as his client, which is a violation of the Code of Professional Responsibility. So the presence of competition invited suspicion of unfaithfulness or double dealing, and consequently the Supreme Court decided to suspend Attorney Balicod from the practice of law for 6 months, warning of more severe penalties for similar future misconduct. Now, let us proceed to Canon 5 of the new Code of Professional Responsibility and Accountability. Canon 5 Equality states that every lawyer shall adhere to the principle of equality and hold firmly the belief that every person, regardless of nationality or ethnicity, color, sexual orientation or gender identity, religion, disability, age, marital status, social or economic status, and other like circumstances, has the fundamental right to equal treatment and representation. As such, the lawyer shall accord equal respect, attention, dedication, and zeal in advancing the client's cause regardless of personal opinion, religious, or political beliefs pertaining to the personal circumstances of the client except for justifiable reasons. So this canon embodies the principle that lawyers must treat all persons equally and refrain from discrimination in any form. It underscores the significance of non-discrimination, fairness, and inclusivity in the administration of justice. This canonical obligation is based on the 1987 Philippine Constitution, particularly Article 3, Bill of Rights, which provides that no person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the laws. So the equal protection mandates that all persons under similar circumstances should be treated alike, both in the privileges conferred and the liabilities imposed by law. Although there is no comprehensive anti-discrimination law covering all protected attributes in the Philippines at the national level, but there are specific statutes that prohibits discrimination based on certain grounds, such as the Magna Carta for disabled persons, Magna Carta of Women, and also in some jurisprudence where the Supreme Court has repeatedly reinforced the principle of equality. On the same manner that there are established international instruments promoting equality, such as the Universal Declaration of Human Rights, International Covenant on Civil and Political Rights, the Convention on the Elimination of All Forms of Discrimination Against Women, or the CEDAW, and the Convention on the Rights of Persons with Disabilities. So, Section 1, Non-Discrimination, states that a lawyer shall not decline to represent a person solely on account of the latter's nationality or ethnicity, sexual orientation or gender identity, religion, disability, age, marital status, social or economic status, political beliefs, or such lawyers or the public's opinion regarding the guilt of said person, except for justifiable reasons. So, this provision sets forth that lawyers shall be aware of and understand diversity in society, which includes differences arising from race, color, sex, religion, national origin, marital status, sexual orientation, social and economic status, age, physical or mental disability, or other like causes. So, this awareness is integral to ensuring that lawyers do not engage in any prejudice or stereotyping. Now, we have a case to demonstrate Section 1 of Canon 5. This case is in red disturbing social media posts of lawyers and law professors with AM number 21-06-20-C, decided on April 11, 2023. And in this case, lawyers faced administrative liability for derogatory, discriminatory Facebook posts against LGBTQIA+ community and judges. So, on June 29, 2021, by resolution issued by the court, it required certain lawyers, Attorney Noel Antay Jr., Attorney Ernesto Tabuhara III, Attorney Israel Calderon, Attorney Morgan Rosales Nicanor, and Attorney Joseph Marion Pea Navarrete to show cause why no administrative charges should be filed against them. So the charges stemmed from a string of Facebook posts that contain derogatory and discriminatory remarks targeting members of the LGBTQIA+ community and making disparaging references to judiciary personnel. Attorney Antay Jr. initiated the online thread by narrating the successful prosecution of a case involving a member of the LGBTQIA+ community coupled with personal accusations and homophobic undertones. So, Attorney Tabuhara contributed remarks that overtly referred to a judge gender expression like wearing eyeliner and eyeshadow, and made unfounded assertions associating homosexual disposition with corruption and mental instability. Attorney Calderon and Attorney Nicanor exchanged comments that reinforced harmful stereotypes by insinuating sexual overtones and engaging in a banter that, despite being couched in jest, carried demeaning implications. So, upon receiving the court's notice, each respondent offered an explanation, with most expressing remorse for their actions and seeking leniency. They emphasized that they harbored no ill intent against the judiciary or members of the LGBTQIA+ community. Additionally, some invoked privacy concerns, as their social media profiles were supposedly private and inaccessible by outsiders or by the public. But after reviewing the submissions, the Supreme Court referred the case to the Office of the Bar Confidant for investigation, report, and recommendation. The OBC recommended that the lawyers be admonished, considering the lawyer's apologies and alleged lack of intent to disrespect. So the court ruled that the lawyer's right to privacy, particularly concerning social media, is not an absolute and cannot be used as a defense for their actions. The court found the lawyers breached the Code of Professional Responsibility. The derogatory posts revealed a lack of respect for individual dignity, promoting stigma against the LGBTQIA community, and undermining public confidence in the judiciary. So the court reprimanded the lawyers with a stern warning against repetition. And that's all for my report. Thank you so much. Wassalamualaikum warahmatullahi wabarakatuh.
Hi everyone, this time I will be reporting about Canon 5, Equality. I am assigned to discuss sections 2 and 3 of the new CPRA. I am reporter number 4, Eduti Bugay. Let's read the provision of section 2. Section 2 of Canon 5 says that treatment of vulnerable person. In dealing with a client who belongs to a vulnerable sector, a lawyer shall be mindful and sensitive of and consider the client's special circumstances as well as the applicable laws and rules. The lawyer shall observe a higher standard of service suited to the particular needs of the vulnerable person and shall assert such person's right to meaningful access to justice. A vulnerable person is a person who is at a higher risk of harm than others and shall include children, the elderly, the homeless, persons with disability, persons deprived of liberty, human rights victims, victims of domestic violence, victims of armed conflict, those who are socioeconomically disadvantaged, those who belong to racial or ethnic minorities, or those with debilitating physical or mental conditions. Let's go ahead and discuss section 2 of Canon 5. It tells us that the definition of a vulnerable person, one who is at a higher risk of harm than others, and shall include children, the elderly, the homeless, persons with disability, persons deprived of liberty, human rights victims, victims of domestic violence, victims of armed conflict, those who are socio-economically disadvantaged, those who belong to racial or ethnic minorities, or those with debilitating physical or mental conditions. Moreover, under this provision, a lawyer shall be mindful and sensitive on how they deal with those that comes from the vulnerable sector. It is a clear command to the lawyer that they should be mindful, maybe by choosing the right words on how they communicate with their client, especially if they come from the vulnerable sector. In terms of being sensitive, it pertains to being sensitive to the current situation, circumstances of their client, because these people coming from vulnerable sector, they have this perception and they see themselves as less compared to other, which is not true, because we know that we are all equal. But these people coming from vulnerable sector, they have that kind of thinking. So the lawyer on this part could be more effective if he can be more sensitive to the circumstances or the current situation of his or her client. It is also contemplated under this provision that the lawyer shall observe a higher standard of service. This does not mean that when a lawyer had a client and he does not come from the vulnerable sector, the lawyer would perform below par or be lenient. That is not implied in this provision. What it tells us is that when a lawyer has a client who comes from the vulnerable sector, the lawyer is expected to observe a higher standard of service because the circumstances or the current situation of those people coming from the vulnerable sector requires them to have a higher standard of service. And lastly, the lawyer shall assert the vulnerable person's rights. Simply put, the lawyer shall champion their rights. We are now about to discuss Section 3, the indigent person. So let's go ahead and read the. Let's take a look at the provision. A lawyer shall not refuse the representation of an indigent person, except if the lawyer is not in a position to carry out the work effectively or competently due to a justifiable cause. Next, the lawyer will be placed in a conflict of interest situation, or the lawyer is related to the potential adverse party within the sixth degree of consanguinity or affinity, or to the adverse counsel within the fourth degree. An indigent is any person who has no money or property sufficient for food, shelter, and other basic necessities for oneself and one's family. The provision simply tells us that lawyers shall not refuse the representation of an indigent person, but there are exceptions. Here are the exceptions. If the lawyer is not in a position to carry out the work effectively or competently due to a justifiable cause. So, only when an a lawyer has a justifiable cause or reason that he cannot be able to fulfill or carry out the work effectively, then he may be exempted to refuse the representation of an indigent person. Another exception is that when the lawyer will be placed in a conflict of interest situation. Whenever there is a conflict of interest, the lawyer will have some weight to freely fulfill his duty, and it might impair him to be effective and efficient at his job. So this is an exemption. Another exception that we have is when the lawyer is related to the potential adverse party within the sixth degree of consanguinity or affinity, or to the adverse counsel within the fourth degree. So if by somehow the lawyer is related, whether by consanguinity or affinity up to the sixth degree, to the adverse party, then the lawyer may be allowed to refuse to represent an indigent client. Or on the other situation, if the adverse counsel it is within his fourth degree of consanguinity or affinity, then the counsel once again may be allowed to refuse to accept or to represent the indigent client. Let us not forget that under this provision, it provided us the definition of what an indigent person is. It, it says that any person who has no money or property sufficient for food, shelter, and other basic necessities for oneself and one's family. So, this is the definition of an indigent person under Section 3, Canon 5. Let us now proceed to case number 1 related to the provisions that we have just tackled. We have Ramirez versus Buhayang Margalio. Reynaldo Ramirez was involved in a land dispute known as the Spouses Roque versus Ramirez. Attorney Mercedes Buhayang Margalio offered her services to the petitioner for 30% of the land subject which is under dispute instead of accepting regular attorney's fee or accepting regular fees. She also asked a fee of 1,000 pesos per court appearance. The RTC ruled in adverse of Ramirez, meaning that the ruling was against the petitioner. Then, Attorney Margalio advised to file an appeal in Court of Appeals. After that, the Court of Appeals ordered Ramirez to file the appellant's brief. This, this is where all the ruckus had started. On several occasions, Ramirez kept on reminding Attorney Margallo regarding this document, but to no avail. After the long wait, after Margallo finally informed Ramirez that the appeal was denied. This is due to Ramirez's failure to establish his affiliation with his alleged father, which was the basis of his claim. When Ramirez went to the Court of Appeals, he found out that the appellant's brief was filed late with a motion for reconsideration and apologies for filing beyond the reglementary period. Because of this, he was aggrieved. Ramirez filed a case against Attorney Margallo for her misconduct as a litigator. The issue in this case was the expectation to maintain a high degree of legal proficiency and attention, whether the represented party is a high-paying client or an indigent litigant, was violated by Attorney Margallo. The court's ruling: yes, respondent Attorney Margallo was unjustifiably remiss in her duties as legal counsel to Ramirez. The lack of communication with her client was palpable. Complainant Ramirez lost his entire case and left him with no appellate remedies. His legal cause was orphaned not because a court of law ruled on the merits of his case, but because a person privileged to act as counsel failed to discharge her duties with the requisite of diligence. Respondent Attorney Margallo failed to exhaust all possible means to protect complainant Ramirez. Thus, herein respondent failed to fulfill the expectation to maintain a high degree of legal proficiency and attention, whether the represented party is a high-paying client or an indigent litigant. Let us now proceed to case number 2, Eusebio de Sison versus Attorney Lourdes Felina Bidumlao. The facts of the case: Dr. Eusebio de Sison consulted Attorney Dumlao, his friend, for the purpose of filing an annulment case against his wife, Dr. Cynthia V. Cervantes Sison. He deposited 35,000 in Attorney Dumlao's bank account for the psychiatric evaluation fee. However, 9 months have passed and Attorney Dumlao was still unable to file the case. So then, the petitioner asked that his money should be returned. However, Attorney Dumlao refused to do so. This is why he filed a case for violation of the Code of Professional Responsibility and the lawyer's oath. Attorney Dumlao replied that he already referred the petitioner to a psychiatrist known as Mr. Domenden. So, fast forward, the petitioner was examined and had received his result. However, the case was already ongoing. A recommendation for dismissal was issued due to the argument of Attorney Dumlao. It was considered as a valid argument. Conflict of interest pertaining to her familiar relationship with Dr. Cervantes Sison. Also, according to Attorney Dumlao, there is lacking of lawyer-client relationship between Sison and Attorney Dumlao. What happened next is that Dr. Season filed a review of certiorari and insisted that there was a lawyer-client relationship. Further, he essayed that he was prejudiced for abandoning his cause without prior notice when Attorney Dumlao withdrew her engagement, which is a violation of the Code of Professional Responsibility. The issue of this case: did Attorney Dumlao violated the Code of Professional Responsibility when she failed to inform complainant of the status of his case and refused to represent him due to conflict of interest? So this is the court's ruling. Yes, Attorney Dumlao did actually entertain through text messages of the petitioner regarding consultations and updates of the case. The court further narrated that a lawyer-client relationship is established when a lawyer voluntarily entertains a consultation, regardless of the close relationship between the parties or the absence of a written contract or non-payment of legal fees. Once a lawyer agrees to take up the client's cause, the lawyer must serve the client with diligence and competence. A lawyer who is negligent in attending to a client's cause may be grounds for administrative sanction. This is why Attorney Dumlao violated the Code of Professional Responsibility. So here ends my part to deliver and report sections 2 and 3 of Canon 5 of the new CPRA. Thank you for bearing with me. You have a great time. Thank you.
Assalamualaikum. Good day. I am Jahana M. Yap and I will discuss the last section of Canon 5 and the first section of Canon 6. So let us start. Canon 5, Section 4. Standard of Service. A lawyer shall observe the same standard of service for all clients, regardless of remuneration, except for the higher standard required for representation of vulnerable persons. This provision states the ethical obligation of lawyers regarding the quality and consistency of their service. The first principle of this provision talk about equal standard of service for all clients. A lawyer must provide the same level of diligence, competence, and commitment to every client, regardless of how much they are paid. Legal representation shall not be compromised based on clients' financial status, whether a lawyer is working pro bono for a low-paying client or for a well-paying client. Their duty to act in the best interest of their client shall remain the same. The second principle of this provision talk about higher standard for vulnerable persons. The provision acknowledges that some clients require additional care, sensitivity, and protection due to their vulnerability. Vulnerable persons may include children, elderly individuals, persons with disabilities, or marginalized communities, which includes indigenous people or victims of abuse or exploitation. In dealing with vulnerable clients, a lawyer is expected to go beyond the standard level of service, which may involve providing extra guidance, which they have to explain legal concepts in simpler terms to ensure understanding or ensuring informed consents. So making sure that the client fully comprehend their legal options and their rights. They also have to take additional protective measures. This provision ensures that lawyers do not prioritize financial gain over their professional duty and acknowledges that need for special care when dealing with vulnerable individuals by maintaining these ethical standards. The legal profession upholds public trust and ensures equal access to justice. This provision explains the case of Tuano E. Hernandez versus People with GR number 205871. So for the fact of this case, Ruel Tuano was charged with violating RA 9165 or the Comprehensive Dangerous Drugs Act for possessing 0.064 grams of shabu. The RTC found him guilty and sentenced him to 12 years and 1 day to 20 years of imprisonment, along with a 300,000 pesos fine. The Court of Appeals affirmed Tuano's conviction in 2012. He sought relief from the Supreme Court, and while his appeal was pending, he died on March 1, 2015. However, his lawyers from the Public Attorney's Office failed to inform the court and continued to file pleadings on his behalf. It was only through the letter of the Bureau of Corrections that the court found out that Tuano has already died. As a result, the court continued to act on the case and even issued a resolution acquitting Tuano on June 27, 2016. That was 1 year, 4 months, and 15 days after his death. For the issue, whether or not the public attorney's office lawyers erred in failing to inform the court of their client's death. Rulings: yes, the Supreme Court ruled that the public attorney's office lawyers representing Tuano remissed in their duty under Section 4, Canon 5, which requires lawyers to exercise the same diligence for indigent client as for the paying clients. The lawyer's failure wasted judicial resources and led the court decide on a moot case. So the court directed them to show cause within 5 days why no disciplinary action should be taken for failing to inform the court of their client's death. Let us now proceed with Canon 6, Accountability. By taking the lawyer's oath, a lawyer becomes a guardian of the law and an administrator of justice. As such, the lawyer shall observe the highest degree of morality, adhere to rigid standards of mental fitness, and faithfully comply with the rules of the legal profession. Failure to honor this covenant makes the lawyer unfit to continue in the practice of law and accountable to society, the courts, and legal profession as well as the client. So, Canon 6 of the CPRA highlights the lawyer's duty to uphold the highest ethical, moral, and professional standards. By taking the lawyer's oath, a lawyer becomes a guardian of law and an administrator of justice that shall adhere to morality, mental fitness, and legal rules. So failure to meet these obligations makes a lawyer unfit to continue practicing and accountable to these four entities. So the society for maintaining public trust in our legal system, the courts for ensuring the integrity of judicial proceedings, the legal profession for upholding the honor of the profession, and lastly, the client for providing competent and legal representation. Ultimately, a lawyer's duty is not just a profession, but a solemn responsibility. Any violation can lead to disciplinary sanction, including suspension or disbarment. Canon 6, Section 1, Nature of Disciplinary Proceedings Against Lawyers. Disciplinary proceedings against lawyers shall be confidential in character and summary in nature. Nonetheless, the final order of the Supreme Court shall be published like its decision in other cases. This provision emphasizes the nature of disciplinary proceedings against lawyers. These proceedings are first, confidential in character, This ensures that the reputation of both the lawyers and legal profession is protected while the case is pending. Second, summary in nature. The process is expedited, avoiding unnecessary delays while ensuring due process. However, once the Supreme Court issued a final order, it is published like other decision. This serves as a precedent and reinforces the accountability of lawyers, promoting public confidence in legal profession. This provision explains the case entitled in the matter of proceeding for disciplinary action against Attorney Vicente Raul Almacen with GR number L27654. This case involves disciplinary proceedings against Attorney Vicente Raul Almacen, initiated after he made public and contemptuous statements against the Supreme Court in response to the denial of his client's appeal. So, for the facts of the case, Attorney Vicente Raul Almacen represented the defendant in the case of Antonio Calerio versus Virginia Yaptinchay. The trial court ruled against his client and Almacen filed an appeal with the Court of Appeals. However, his appeal was dismissed due to procedural defects, specifically his failure to properly notify the adverse party of his motion for reconsideration. Attorney Almacen sought a review within the Supreme Court, which was also denied his petition via a minute resolution without a detailed explanation. His motion for reconsideration was also denied. Frustrated by these rulings, he filed a petition to surrender lawyer's certificate of title in protest. In his petition, he accused the Supreme Court of injustice and corruption, stating that justices were calloused and deaf, dumb, and blind to pleas for justice. Claimed the Supreme Court ignored its own precedents and violated the Constitution. Declared his intention to argue his case in the People's Forum rather than the judiciary. His accusations were published in the Manila Times, where he accused the Supreme Court of arbitrarily denying appeals without reason and condemned its practice of issuing shortcut to justice. His accusations were further publicized by the Manila Chronicles in a column by Vicente Albano Pasis, which noted that his statements amounted to an impeachable offense against the Supreme Court. The Supreme Court treated his petition and public statements as contemptuous and initiated disciplinary proceeding against Attorney Almacen. For the issues, whether or not Attorney Almacen's public statement against the Supreme Court constitute professional misconduct. So, the ruling, yes, Attorney Almacen was found guilty of gross misconduct and contempt. His statements were deemed insulting, defamatory, and destructive to public confidence in the judiciary. The Supreme Court emphasized that lawyers are officers of the court and must maintain respect for judicial institutions. His accusation, made publicly through the Manila Times and other media, violated professional ethics. As a result, he was disbarred and permanently prohibited from practicing law. So, for the other issue, is that whether or not disciplinary proceedings against lawyer should remain confidential. So, for the rulings, yes, the Supreme Court reaffirmed that disciplinary proceedings against lawyers are confidential to protect the reputation of legal practitioners from baseless accusations. However, the final decisions must be published to ensure public accountability and transparency.
Assalamu alaikum warahmatullahi wabarakatuh. I am Morsid S. Bilao, and I am here to continue the report of my colleague that is about accountability. So this canon or canon 6 of the Code of Professional Responsibility and Accountability focuses on the principle that a lawyer must be accountable for all aspects of legal representation, including the handling of client funds, use of client confidences, compliance of ethical rules, and upholding public interest. So let us now continue. Let's proceed with the section 2 that talks about the institution of disciplinary proceedings against lawyers. So for this section, it may be commenced by the Supreme Court motu proprio on its own initiative or upon the filing of a verified complaint by the Board of Governors of the Integrated Bar of the Philippines or by any person before the Supreme Court or the IBP. So please note, however, that in cases where the disciplinary action is sought against a government lawyer who is a member of the bar, the complaint shall be filed exclusively in the Supreme Court. So a verified complaint submitted to the Supreme Court can be forwarded to the IBP for investigation and reports. However, if the complaint is filed directly by the IBP, it will be referred to the office of the bar confidant or another designated fact-finding body for processing because it's not the Supreme Court who personally investigate, but it is the IBP who will be conducting the investigation. So, how about if the incumbent justices of the Court of Appeals, Sandigan Bayan, Court of Tax Appeals, or the lower court judges or against lawyers in the judicial service are being complained to? So, complaints alleging serious misconduct such as actions warranting disbarments, suspension, or disciplinary measures against those mentioned justices, it will be forwarded by the IBP to the Supreme Court for appropriate actions. So this process is governed by the Rule 140, which basically it outlines the procedures for dealing with such complaint. So here, it doesn't matter if the complaint involves one person or more. The Supreme Court will be responsible for with regard to this matter. Now, for Section 3, the contents of the complaint. The complaint shall be verified. The complaint shall be verified. It shall state clearly and concisely the acts or omissions complained of and shall be supported by judicial affidavits of the witnesses in such other documents in support thereof. When you say judicial affidavits, these are sworn statements executed by a witness that and it serves as direct testimony in court. So if the verified complaint is filed before the IBP, 6 copies thereof shall be filed with the secretary of the IBP or the secretary of any of its chapters, who shall forthwith transmit the same to the IBP Board of Governors. All right. So, in the case of disbarment proceedings against Attorney Diosdado Gutierrez, this is a um, this is actually it. This case revolves a lawyer convicted of murder, granted a conditional pardon, was disbarred as the pardon did not absolve moral turpitude, upholding legal profession standards. So, for the facts of the case, the respondent here, Diosdado Q. Gutierrez, is a member of the Philippine Bar, admitted on October 5, 1945, held a distinguished position within the legal profession until his involvement in criminal proceedings. So there is a criminal case against him um, from the Court of First Instance of Oriental Mindoro. He was actually convicted of the murder of Philemon Samaco, the former municipal mayor of Calapan. So originally, he was actually sentenced to death along with his co-conspirators, and the sentence was later modified by the Supreme Court to reclusion perpetua. So after serving a portion of his sentence, Gutierrez was granted a conditional pardon by the President Garcia on August 19, 1958. So on October 9, 1958, the widow of the deceased former mayor, um, Philemon Samaco, filed a verified complaint in the Supreme Court seeking the disbarment of Gutierrez. Um, and Gutierrez actually admitted the facts of his conviction but pleaded that the conditional pardon, by analogy to the precedent in Lontok, should preclude his disbarment. So the issue here is whether the conditional pardon granted to Gutierrez operates as an absolute exoneration that should preclude disbarment proceedings based solely on the conviction. And also, the second issue here is whether the conditional pardon effectively erases the moral turpitude attached to the offense, thereby negating the ground for disbarment. Now, for the ruling of the case, the Supreme Court held that the conditional pardon does not operate to clear the record of conviction to the for the purposes of disbarment. So the respondent Gutierrez is disbarred, and his name is ordered to be stricken from the roll of lawyers. And also the court emphasized that the ruling in Riluntok, where the pardon was absolute, it cannot be applied by analogy to cases involving a conditional pardon. And also, it was affirmed that only a full pardon, again, absolute pardon, eliminates the record of conviction, whereas a conditional pardon leaves the substantive offense on record. So, in this case, the doctrine established by this case, again, it emphasizes that the legal profession is a privilege granted only to those who consistently exhibit high moral and ethical standards. So, a lawyer's admission to the bar is based not only on academic qualifications but also on demonstrable good moral character, which must be upheld throughout one's career. So there's also another case about the disbarment proceedings of Augustus A. Montaigne or Montagne and Frank E. Dominguez. This is a very old case dated on April 2, 1904. So this case revolves revolves about the lawyers or attorneys suspended for 1 year due to gross misconduct, including abandoning clients, failing to file briefs, and misappropriating funds despite leniency. So, in this case, there are um, several charges filed against the two lawyers, against Montaigne and Dominguez. There is a charge here from Balmori, because what happened is that they received, or they were hired by Felix Balmori in February 1902 to represent him in criminal appeal to the Supreme Court. To represent him in a criminal appeal to the Supreme Court. So they received a retainer of $200. They took the appeal but failed to file a printed brief as required by court rules, despite extensions granted by the Solicitor General. The appeal was dismissed on August 18, 1902, due to the failure to file the brief, and Balmori was not notified and later hired another lawyer, leading to his acquittal. So there's also a charge from Hacienda Esperanza. Um, there's also from Cardona, almost same charges. And there's also a charge again from Cardona and Sarmiento, um, and also other charges. No, um, and the respondents were accused of abandoning clients. So the issue here is whether the respondents violated their professional duties as attorneys by abandoning their clients and failing to fulfill their obligations. So whether the respondents' conduct warrants disbarment, or suspension from the practice of law. So the Supreme Court ruled that they found that the respondents are guilty of misconduct in the charges filed by Balmori, Hacienda, Esperanza, Cardona, and Sarmiento charges. No, however, the court imposed a lenient penalty, suspending them from the practice of law for 1 year instead of disbarring them. So in this case, the Supreme Court has exclusive jurisdiction over disbarment proceedings, no? So which are not criminal in nature, but are intended to protect the court and the public from unfit attorneys. So the respondents' failure to fulfill their obligations, the said two lawyers, to their clients, including abandoning cases, failing to file necessary documents, and misappropriating client funds constitutes gross misconduct as defined under Section 21 of the Code of Civil Procedures. So that's for the case of the disbarment proceedings of Augustus A. Montaigne and Frank E. Dominguez. So this is actually a reminder, no, to all aspiring Bangsamoro lawyers, no, future lawyers, that it is imperative that we should remain mindful of our actions in words, and we should recognize that there would be potential consequences in the realm of professional conducts and ethics of such actions. So every decisions that we make, whether in legal practice or personal lives, it carries weight and could probably, or it could ultimately impact our status, our standing within the legal community. So, if we understand the gravity of our responsibilities, let us also prioritize integrity, prudence, and adherence to ethical standards to avoid the risks of disciplinary measures that would jeopardize our careers, no, and the trust bestowed upon us by our clients and the society as a whole or at large. So that's all. Thank you so much for listening.
Hi everyone. Let us continue discussing the Canon 6 sections 4, 5, and 6 of the Code of Professional Responsibility and Accountability. Section 4 List of Investigating Commissioners' Qualifications. This section specifically addresses the selection and qualifications process of investigating commissioners. And this process includes the IBP of 9 regions will conduct a selection and qualification process. In our political regions, we have 17 administrative regions and one autonomous region, which is the BARM, and a total of 18 political regions. But unlike in IBP, we only have 9 regions, and these 9 regions will select 150 lawyers in good standing and repute, and it will be recommended by the IBP to the Supreme Court together with their curriculum vitae. And those approved by the Supreme Court may be designated as investigating commissioners who shall serve for a term of 3 years unless sooner removed, replaced, or resign. These investigating officers were required to take their oath in the form prescribed by the IBP. The copy of their appointment and oath will be transmitted to the Supreme Court. Section 5 Assignment by Raffle of Investigating Commissioner. Section 5 states that the IBP Board of Governors shall assign by raffle an investigating commissioner from among the lawyers approved by the Supreme Court in the list submitted by the IBP, or, when a special circumstance so warrant, a panel of 3 investigating commissioners to investigate the complaint. Section 5 provides us the substantial steps in conducting disciplinary actions, which ensures the fairness and impartiality in the selection process by preventing bias and influence in choosing the investigating commissioner or commissioners. For disciplinary cases against the lawyers, it shall be heard by a panel of at least 3 investigating commissioners assigned by raffle by the IBP Board of Governors from among the lawyers approved by the Supreme Court in the list submitted by the IBP. The Section 5 of Canon 6 promotes transparency and integrity in the disciplinary proceedings against lawyer. Section 6 Complaint against a government lawyer. Section 6 states that when a complaint is filed against a government lawyer, the investigating commissioner shall determine within 5 calendar days from assignment by raffle whether the concerned agency, the ombudsman, or the Supreme Court has jurisdiction. If the allegations in the complaint touch upon the lawyer's continuing obligations under the CPRA, or if the allegations, assuming them to be true, make the lawyer unfit to practice the profession, then the investigating commissioner shall proceed with the case. Otherwise, the investigating commissioner shall recommend that the complaint be dismissed. Section 6 explained to us that if allegation of the complaint is a violation of obligation under the CPRA, or if the behavior violates the CPRA's ethical standards, then the investigating commissioner proceeds with the investigation under the CPRA framework. But if public officers being charged for action allegedly under or discriminatory involving their official functions during their tenure, the present case should be resolved by the Office of the Ombudsman as the appropriate agency. The IBP has no jurisdiction over government lawyers who are charged with administrative offense involving their official duties. This provision will ensure that complaints are addressed by the appropriate authority, maintaining the integrity and accountability of legal professionals in the government service. Take note, IBP has no jurisdiction to investigate lawyers of the government charged with administrative offenses involving the performance or discharge of their official duties. We have this administrative case involving the government lawyers. The case of Clarita Mendoza and Clarice Mendoza versus Attorney Limel bin Nobleza, Attorney Honesto de Noche, and Attorney Randy C. Caintal. Administrative case number 11433, formerly Commission Bar Discipline case number 17-5307. Facts of the case. Complainants Clarita Mendoza is accused in a criminal case for unjust vexation, while Clarice Mendoza is accused in another criminal case for violation of Republic Act number 7610 or child abuse law. Complainants claim that the criminal cases filed against them were offshoots from preliminary investigation conducted by Senior Associate City Prosecutor Attorney Randy Sicaintal, recommended for approval by Deputy City Prosecutor Attorney Honesto D. Noche, and approved by City Prosecutor Attorney Limel B. Nobleza. The complainants allege that the respondents committed gross ignorance of the law or procedure and violation of the Code of Professional Responsibility and violation of the lawyer's oath. Issue whether the respondents qualify for disbarments on allegations of unethical conduct for gross ignorance of the law or procedure, violation of Code of Professional Responsibility, and violation of the lawyer's oath. The court decision. The Supreme Court dismissed the disbarment complaint, finding it to be without merit. The court emphasized that the complaints failed to provide sufficient evidence to substantive their claims against the respondent prosecutions. The court also noted that filing of disbarment complaints against government lawyers without sufficient basis could be seen as an attempt to harass or intimidate them in the performance of their duties. On the allegation of gross ignorance of the law or procedures, the court held that these allegations are not meritorious because the victims in the unjust vexation case and the RA 76 case are minors. On the allegations of to the respondents recommended excessive bail, complainants presented no proof of this allegation in the complaint, and because the respondents were able to show the recommended bail in pursuant to DOJ Series of 2000 Bail Bond Guide, which clearly pegs the amount of bail for the violation of Section 10, Paragraph A of RA 7610 at 80,000 pesos. Also, the respondents filed the unjust vexation case in the RTC. Thus, the jurisdiction to try the case is correctly within the family court. And on the allegations of violation of the Code of Professional Responsibility and violation of the lawyer's oath, the complainant claimed that respondents had falsified or fabricated the unjust vexation case against the former, that there is no preliminary investigation conducted for an offense that happened stated in the information dated February 20, 2016 does not match the date of the offense February 8, 2016 in the resolution and misrepresenting this error as an unethical act of fabricating or falsifying a case. The investigating commissioner discussed that a typographical or clerical error is not a novel or fatal issue considering that all other records and evidences submitted refer to February 8, 2016. It can be corrected by a formal amendments of the information. So therefore, the department complaint against respondents Attorney Limel bin Nobleza, Attorney Honesco de Noche, and Attorney Randy C. Caintal is dismissed for lack of merit. In this case, the Supreme Court underscored the importance of protecting the government lawyers from the unfounded disbarment complaints that may hinder their ability to perform their official functions effectively. The court highlighted that while lawyers are expected to uphold the law and adhere the ethical standards, accusations against them must be supported by substantial evidence. The decision serves as a reminder that this disbarment process should not be misused as tool for harassment or to impede the administration of justice. Thank you.
And that's conclude the discussion of Group 4 on Canons 4, 5, and 6. If you want to access the full version of those cases as mentioned by the reporters, kindly click or copy paste this link. Again, Assalamualaikum warahmatullahi ta'ala wabarakatuhu. Good day everyone.